Hello, I'm Professor Eugene Kontorovich, professor at George Mason University, Scalia Law School, right outside of Washington, D.C., where I teach constitutional and international law. And I have filed an amicus brief in the Polish Constitutional Tribunal about possible constitutional problems raised by the Istanbul Convention, which Poland has signed. Now, this treaty is unlike pretty much any other human rights treaty. It is both more expansive in its agenda and more limited in the protections it affords states than any similar treaty. And it goes so deeply into the internal, domestic, and cultural life of states that it potentially violates numerous aspects of the Polish Constitution. Now, I'm not an expert on the Polish Constitution. I'm an expert on international law and constitutional law generally. And what I can say is it is certainly the case that this treaty has the potential to be interpreted by the commission that has interpretive authority under it, that is delegated interpretive authority in ways that are likely to conflict with the Polish Constitution, of course, depending on how that is ultimately interpreted. So one major difference between this treaty and other treaties is this treaty is described by its drafters, by the Council of Europe, as a manifesto. It is an ideological document, and it says that it is about violence against women, but in fact, its agenda is much broader because the convention has a theory behind it. And that theory that violence against women is caused not simply by bad people, by lawless and violent people, but rather it is fundamentally caused by deep root causes in society, in particular, stereotyped views of men and women, or rather traditional gender roles as social stereotypes. And so the treaty says that its goal was not simply to prevent violence against women, because it says you can't do that without fundamentally changing society and the way they view men and women in general, outside of any context of violence. And that is what the treaty seeks to do. And that is why so much of the rhetoric around this treaty is so heated. Critics of the treaty are accused of engaging in ideological war, of patriarchy and misogyny. This is not normally the kind of rhetoric one hears in disputes about whether a country should be a member of a treaty. But again, there's a fundamental ideology behind it to require and empower countries and bind them under international law to, in many ways, transform their societies in ways that would address what the treaty sees as root causes of violence against women. So, for example, Article 3 of the treaty defines gender as not simply being the biological fact of being a man or a woman, but also gender as a social construct. In other words, as an idea which suggests that people can shape or decide on their own genders. Separate provisions ban discrimination on the grounds of gender identity, which would be a situation in which a man identifies as a woman or vice versa. So when read together, these provisions could be understood as requiring states to recognize the marriage of two men or the marriage of two women if one of them identifies as a member of the opposite sex. Another extraordinarily broad provision, Article 12, is so vast that it is it's simply startling. It requires countries who join the convention to take the necessary measures to promote changes in the social and cultural patterns of behavior of women and men, with a view to eradicating customs, traditions, and all other practices which are based on stereotyped roles for women and men. So again, the goal is that the requirement is that countries change the society and culture to eradicate traditions and customs based on stereotyped roles for men and women. And these need not be negative stereotypes. They could simply be traditional family stereotypes. Whether such stereotypes are good or bad, this is quite extraordinary in that it requires the state to actually be actively involved in warring against the culture and traditions of the people, which poses many potential problems under the Polish constitution, in particular, about the impartiality of the government in matters of people's belief and life outlooks, Article 25, the freedom of private life, Article 47, and the freedom of religion, Article 53. Article 13 and 14 require the government to provide an education focused on molding people's attitudes and convictions early in life. Indeed, the scientific advisor for the drafting of the convention claims that the Article 14 mandates sex education in public schools. Again, this could be understood as interfering with parents' freedom to control their child's education and the neutrality of the state in matters of public life. Article 40 adopts a definition of sexual harassment far broader than currently existing under Polish law. Under Polish law, it is limited to an employment setting where an employer has power over an employee. The convention would require that the law be changed to allow for people to sue for harassment based even on something like jokes in any context. So simply online jokes, anonymous online jokes, could become the subject of lawsuits in a way that could potentially chill free speech. Now, it's not clear whether these whether these provisions violate the Polish constitution, because it's not clear exactly what all of them mean, how broadly they can be interpreted. They can all be interpreted more and less broadly. Unfortunately, the two tools for interpreting them narrowly are not available under the convention. One way to allow countries to interpret provisions narrowly is to allow the country to be the primary authority for interpreting what the treaty means. The Istanbul Convention does not take that approach and instead sets up a special committee of experts on violence against women and gender equality to interpret its meaning. And based on how such commissions under other treaties have functioned in the past, one can expect them to adopt fairly expansive interpretations over time. Now, most treaties want to encourage lots of countries to join. Most human rights treaties, the goal is not actually enforcing the treaty, because they're generally not enforceable. The goal is to get lots of countries to sign on to these broad statements of nice ideas. And because you want many countries to sign on, as many as possible, it can't be too specific. So as a result, human rights treaties, most of the time, almost all of the time, allow for countries to opt out of provisions that violate their constitutions or that might violate their constitutions potentially, which is called making a reservation to the treaty. The Istanbul Convention bans such reservations for all of these potentially problematic provisions, which means you can't simply sign up to the treaty for the parts that would be constitutional and choose to opt out for the parts that would not be. This makes it very difficult for a country with a constitution, especially a constitution that takes an approach to the biological nature of gender and marriage and childbearing that may not be shared through the rest of the Council of Europe, to enter into this treaty without creating a conflict with its laws. This is something that must be borne in mind, and it is not a criticism of Poland to say that the Istanbul Convention violates its constitution. That is to say, there's nothing wrong with Poland's law or constitution that would result in such a violation. Rather, it is the fact that the drafters of this convention have taken the very unusual approach of not allowing reservations to the treaties, which most Western democratic countries undertake when they enter most human rights treaties. I hope the tribunal finds my contribution helpful in assessing these issues.